I call this meeting to order. Before we begin, I'd like to mention that in the name of all colleagues and personally to wish everyone a good International Women's Day, and to all our feminine colleagues and panelists present today. As you can see, our agenda reflects that important day today. So welcome to meeting number 53, the House of Commons Standing Committee on Justice and Human Rights. Pursuant to Standing Order 108 sub 2 and the motion adopted on January 30th, 2023, the committee is beginning its study on Canada's bail system. Today's meeting is taking place in a hybrid format pursuant to the order, the House Order of June 23rd, 2022. Members are attending in person in the room and are remotely using the Zoom application. I'd like to make a few comments for the benefits of the witnesses and the members. Please wait until I recognize you by name before speaking. For those participating by video conference, click on the microphone icon to activate your mic, and please mute yourself when you're not speaking. Interpretation for those on Zoom, you have the choice at the bottom of your screen of either English, French, or floor. For those in the room, you can use the earpiece and select the same similar desired channel. Reminder that all comments should be addressed through the chair. For members in the room, if you wish to speak, please raise your hand. For members on Zoom, please use the raise hand function. The clerk and I will manage the speaking order as best as we can, and we appreciate your patience and understanding in this regard. The Speaker's ruling in the House on March 6th regarding virtual meetings. Briefly, I'd like to remind all of us that the Speaker wrote his ruling regarding virtual meetings. As per Monday, interpreters will not be able to provide simultaneous interpretation if members and all witnesses in the case of committees participating remotely are not wearing the appropriate headsets. Thank you. So now we'll resume our study on Canada's bail system, and appearing today we have as an individual Dr. Nicole Myers, Associate Professor from Queen's University, my alumni, so I'm very happy as alma mater. And then also from the Canadian Association of Elizabeth Fry Societies, Emily Coyle, Executive Director via video conference, and from the London Abused Women's Centre, Jennifer Dunn, the Executive Director. We welcome you and are glad to have you here. You have the floor for 5 minutes, and as usual, your opening remarks will be followed by questions from the members of the committee. I have cue cards, so when you're about 30 seconds into it, remaining, I'll raise the yellow card, and when you're done, the red card, I just ask you to wrap up at that time so I don't have to interrupt you. And the same goes for members. Welcome, Ms. Vecchio, to the committee. So I'm a little old school. I use cue cards. Yes, we'll begin with Dr. Nicole Myers for 5 minutes.
Monsieur le Président.
Sound tests have been done, and we are good to go, Monsieur Fautin.
Merci, Monsieur le Président.
Thank you.
Thank you, Mr. Chair and members of the committee, for the invitation to speak with you today. My name is Dr. Nicole Myers, and I'm Associate Professor at Queen's University, and I've been studying issues around bail and pretrial detention for almost 20 years. Following a tragic event, it is understandable that people are upset and concerned about what's happened here, especially the police, and they'd like to find a way to make sure this does not happen again in the future. I agree that our bail system merits review and attention. Now, while a tragic incident may be what motivates a critical review of the law and the operation of the system, systematic empirical data needs to be what informs our conclusions about the system and directions for change. When we think about bail, we must be mindful of the foundational principles of the criminal justice system and the rights enshrined in the Charter of Rights and Freedoms, including the presumption of innocence and the right to reasonable bail. The Supreme Court of Canada has emphasized that restraint must be exercised in the bail decision, with the starting position being that accused are to be unconditionally released. To hold people accountable for their actions and to sanction and punish behavior, we must first convict people of the offense for which they've been charged. Attempts to predict What do we know? We know that Canadian crime rates, including the violent crime rate, continue to be at historic lows. However, the bail decision in Canada has become generally more restrictive and more risk-averse over time. For example, in Canada, the number of people in pretrial detention has exceeded the number of people convicted and sentenced to provincial custody since 2005 and 6. In 2021-2022, 70.5% of the provincial jail population across Canada was in pretrial detention. The rate with which we use pretrial detention has more than doubled in the last 40 years, and the number of people in pretrial has quadrupled in this time. Given the rate, number, and proportions of people in remand, it is clear that Canada is not lenient when it comes to pretrial detention. Many people are serving time before they have been found guilty. Now, one of the biggest difficulties that we face is that there's no accurate, reliable way to predict who's going to go on to commit crimes in general or serious violent offenses in particular. Our criminal justice system cannot and should not be expected to identify, address, and eliminate all future risks. Any attempts to predict risk are both unreliable and discriminatory, especially against Indigenous peoples, Black people, and other racialized communities. The law already provides mechanisms to keep people in pretrial custody where appropriate, including for reasons of public safety. Keeping people in pretrial detention removes them from the community and may provide some short-term public safety. This protection, however, is temporary and is undermined by longer-term negative public safety outcomes. Custody is not only incredibly expensive, it is criminogenic. Even short periods of time in custody make it more, not less likely that someone will commit further offenses in the future. The specific proposal to create more reverse onus provisions is not an effective way to achieve the objective of enhancing public safety. Reverse onus provisions are problematic and unnecessary, as they fail to acknowledge the inequality of power and resources between an accused person and the state. When a person's liberty is at stake, the state ought to bear the onus of demonstrating that detention is justified, rather than an accused person bearing the onus of demonstrating why they ought to be released. If the risk of an accused is significant, the Crown will make these submissions to the court, and an accused can be detained. And if they are released, they will be subject to conditions and monitoring in the community. It is a slippery slope to pursue making the system more restrictive when our provincial jails are already full of legally innocent people. Tightening the bail system and increasing our reliance on pretrial detention will have discriminatory outcomes on the most marginalized, the most over-policed, the most disproportionately incarcerated in society, compounding disadvantage, having the opposite of our intended effect of making the communities less rather than more safe. The best way forward is through a thorough and principled review of the law that brings together justice system actors and community stakeholders to consider the purposes of bail and how to best balance rights with public safety. We might consider that rather than making amendments to Section 515 of the Criminal Code, we step back and reconceptualize and fully replace the law on bail with recent Supreme Court of Canada decisions in mind, explicitly outlining principles, objectives, directions for how decision makers are to exercise their discretion. We should set up and encourage the police to use their powers of release, including judicial referral hearings that were created by Bill C-75. Having fewer minor matters starting in bail court will give the courts more time and resources to focus on those that are more risky or more serious. Improving efficiency in case processing, including access to justice, more funding for legal aid, will help reduce the number of people that are held in custody, as well as the amount of time that people are detained or subject to conditions in the community. We might think about developing specific principled hurdles to detention. The crisis in our bail system is not one of an overly lenient or lax system. What happened is undoubtedly tragic. Allegations of violence, especially repeat violence, are concerning. There are opportunities for reflection and change. The question, however, is one of priority. Are we more interested in short-term or long-term public safety? I encourage everyone to uphold the principled purposes and limits of the criminal law by prioritizing the latter. Thank you.
Thank you, Ms. Myers. Next, we'll go to Emily Coyle from the Canadian Association of Elizabeth Fry Societies.
Thank you so much. I will be reading from my notes on my computer, although I will periodically be seeing if you're holding up a yellow card. Hello, everyone. It's lovely to be with you this afternoon. And as many of you know, the work of the Canadian Association of Elizabeth Fry Societies, or CAFES, as we call it for short, has been playing a key role in shaping services and policy direction for Canada's population of federally sentenced women and gender diverse people, as well as those at risk of incarceration since 1978. We do this all while envisioning a world with strong and well-resourced communities where everyone has what they need. I come to you today from the traditional land of the Lenape people on what is now known as Manhattan. CAFES also works to address the persistent ways in which the women and gender diverse people who are impacted by criminalization are routinely denied their humanity and are excluded from considerations of community. The efficacy of our bail system is a critical conversation to have, as many of the criminalized women and gender diverse people we work with and alongside are denied humanity and excluded from community through lack of access to bail. A clear demonstration of this was a discussion that was relayed to me recently about the locating of bail court at the Finch Street Courthouse in Toronto. This decision was applauded by some, as it meant that it was closer to the Vanier Jail, the provincial jail for women, a shorter distance to transport the people who were denied bail. I believe that this message is quite clear. Today, I'm so happy to be joined by Dr. Nicole Myers. Those of you who have paid attention to our website recently would know that CAFES, along with the Canadian Civil Liberties Association and Dr. Nicole Myers, sent a letter to the Prime Minister and the Minister of Justice on this very topic at the end of January. And I will discuss some of what we have in that letter, as well as some additional reflections on this topic. And so we addressed our concerns in the letter sent by the premiers of the provinces on bail reform. In this letter, we highlight the contradictions that we believe is the direction that is being taken for bail reform that the premiers have proposed. And in particular, we're deeply concerned with what appears to be a complete lack of attention paid to an extensive body of research documenting the current operation of judicial interim release in Canada. As Dr. Nicole Myers has already pointed out, there are more people today in pretrial detention than there are people who are serving custodial sentences in our provincial and territorial jails. And we emphasize the foundational premise of our judicial system, which is the presumption of innocence. And hand in hand with that premise is the right to reasonable bail and the dismal reality that too many people are serving time in detention before they've been found guilty. And I cannot underscore enough the importance of this presumption of innocence. We know this because we in our work see overwhelmingly the power of the state in the lives of the people that we work with. These are people who have very little power, and they're being swept along the tide of the criminal justice system without means to steer their own ship. And as such, we caution that criminal law reform needs to be undertaken very carefully, as any changes could have potentially unintended consequences, particularly for those who are already marginalized. And when a change in reverse onus is suggested, as was proposed by the premiers in their letter, it fails to recognize this tremendous power imbalance between the state and accused persons. And so decisions like this must never be made lightly or reactively. Finally, our letter summarizes some of the more salient points of the evidence pertaining to the operation of bail in Canada, which I won't go into, but I'm happy to answer questions on, as actually I'm sure Dr. Nicole Myers would do a better job than I. Beyond the issues that are raised in our letter, I would be remiss if I did not speak about those who lost their lives in jail while awaiting trial. In Ontario alone, over 280 people have died in custody since 2010, and the link between deaths in custody and bail reform is undeniable. If in Ontario, over 3/4 of the people in our jails are on remand, then there is a direct link between the amount of people in our jails who are on remand and their deaths. Oh my. As a recent report in the Deaths in Custody in Ontario released in December 2022 highlighted, being on remand increases a person's risk of death for a variety of reasons, including heightened suicide, which is 4 times that of the sentenced population, and drug overdose. The report further expands upon these reasons and points to the challenges of adjustment, uncertainty, drug or alcohol withdrawal, disrupted personal relationships, isolation, restrictive conditions, and first-time incarceration. I'll end there, but I welcome all of your questions, and I hope to get to the rest of my comments then. Thank you very much.
Thank you, Ms. Coyle, and I hope members give you that opportunity to flesh out the rest of your comments. Next, we'll go to Jennifer Dunn from the London Abused Women's Centre.
Thank you, Chair, and thank you to the committee for inviting me here today. It is very nice to see all of you again. My name is Jennifer Dunn, and I am the Executive Director of the London Abused Women's Centre, or LOC, here in London, Ontario. LOC is a feminist organization that supports and advocates for personal, social, and systemic change directed at ending male violence against women and girls. LOC is a non-residential agency that provides women and girls over the age of 12 who have been abused, assaulted, exploited, trafficked, or who have experienced non-state torture with immediate access to long-term trauma-informed, woman-centered counseling, advocacy, and support. So we know in Canada, under the law, a person accused of a crime is presumed innocent until they are proven guilty. Granting bail means they can remain out of jail while they move through the justice system. We also know that the court process can take many, many, many months. I read that the cost of keeping an accused person in custody is a lot more expensive than the cost of supervising them in the community while they wait for their turn in court. But I ask, a lot more expensive to who? What is the cost of a woman who has to serve a life sentence for being brutally assaulted at the hands of a man while he is out on bail? At the London Abused Women Centre, we have a group of women with lived experience who are paid for their time that help advise us on our work. A couple of weeks ago, I had the privilege of sitting with this group of women for about an hour, and I said to them, let's talk about Canada's bail system. And I took the time to listen to every story they wanted to share. So with their permission, I bring some of this to you today. Quote, they gave him every accommodation. They wanted to give him consideration of not interfering with his work. He is a well-established businessman. End quote. I spoke with a woman whose perpetrator is on bail, and he's allowed to go to work. She also works there, I might add. He is supposed to be supervised at work. He is supposed to stay a certain distance from her, but this simply does not happen. And because this particular man is in a very high position of power, the business seemingly looks the opposite way. Firmer bail conditions in this situation could help this woman to work without fear. She isn't the one at fault. She shouldn't have to find another job to stay safe. Quote, the onus is on you to keep yourself safe instead of the onus being on the abuser to follow his conditions. End quote. I heard from another woman. Quote, as a victim, I feel I have to prove that I'm the victim more than he has been accused of his actions. End quote. My abuser was arrested in my driveway for domestic assault. Less than 12 hours later, he was out on bail. At that time, the abuse has gone on for many, many years, but I had never reported the abuse previously. He breached his conditions and every single day had no true consequences. On Monday, Justice Minister David Lametti said Canadians deserve to be and deserve to feel safe. And I read that the minister said it's important to note that bail laws are clear, that detention of an accused person is justified if it is necessary to protect the safety of the public. But on the ground, from the London Abused Women Centre, this doesn't particularly make sense to us. We have seen instances where police have issued public safety warnings, yet a repeat offender continues to receive bail. And I'm referring to an ex-police officer who spent more than 2/3 of his career suspended with pay for criminal charges and professional misconduct. He was charged with sexual assault with choking, sexual assault causing bodily harm, forcible confinement, and the list goes on. It was in December that the police first issued the public safety warning with his picture and some of the names he has been using online. He faces charges now involving 4 different women and has pled guilty to breaching his bail conditions. Just last week, on the 27th of February, he received bail again. We see time and time again privilege in the system, where perpetrators who have money for the best lawyers are receiving all of the benefits. Even the surety system is made for people with money. The ease at which a perpetrator can receive bail is often seen as excusing the offender's actions, can show a failure to hold offenders accountable, and can be seen as minimizing violent crimes. The women I spoke to are fearful. They are fearful not only of their perpetrators, but of the system that is supposed to be protecting them. Quote, he scores goals. He's well established. He's well known. Bail shouldn't be based on privilege, but sometimes it is. End quote. In closing, the London Abused Women Centre and the women we serve would like to recommend that this committee be sure to use a lens that focuses on those who are most vulnerable. Think of violence against women while studying Canada's bail system. The government must prioritize the rights of victims. Thank you.
Thank you, Ms. Dunn, and thank you for coming again to the committee. We'll go to next, our first round, and we welcome Ms. Vecchio for 5 minutes.
Thanks very much, and thank you so much for having me on this committee today. It's very important that when we're talking about bail reform, when we're talking about the criminal justice system, and when we're talking about victims of violence, sexual exploitation, and those types of things that are interfering in women's lives, and how we must move forward to make sure that we're protecting people. Jennifer, I know I've had the opportunity to work with you several times on different things, everything from sex trafficking and exploitation. We've talked about these types of things. You've talked about some of your clients and the fact that they are scared. When we're talking about the bail reform, we already know that it's very difficult for women to go forward and make these we all already know it's difficult to go to the police. But when there is bail reform and allowing these people back out, it is also they feel lost. They feel like no one's listening. What other stories are you hearing, Jennifer, from some of these women who are talking about the fact that their spouses or their perpetrators have been released on bail? And can you give me an example of how many times perhaps they've been let out on bail? Is it 1, 2, 3 times? What types of data do you have on that?
Thank you so much for the question, MP Vecchio. It's nice to see you. Well, we have many stories every single day that we could go through that are exact examples of this. I think a good example would be the one that I gave while I was speaking, and it's about the police officer that has been, or the ex-police officer that has been in the news as of late here in the city. So he has been he has 4 charges from 4 different women now against him. And he is repeatedly released on bail, even after pleading guilty to breaching. And it's problematic because we have women who access our service every single day who are constantly looking over their shoulder, constantly feeling unsafe, unaware of what's going to happen next. And that's where the problem lies. So you mentioned, women sometimes don't report. And so sometimes that's very tricky for women because when they see in the media or other situations where this is happening, maybe to people that they know, where an individual is being released after doing something absolutely horrible, or it seems as if justice was not served, it makes it that much more difficult for a woman to feel like she will be trusted when she decides to share her story.
Thanks.
And so...
Jennifer, I just wanted to ask, because as you're speaking about this, on Bill C-75, we're talking about the reverse onus. Are people talking, you've talked about even this police officer, showing that they're good. They have to have this reverse onus, proving that they're not going to do it again. Are we hearing the exact opposite, though, from what you're talking about with this police officer and other people within our own community?
Well, I think with what we're seeing on the ground here from the London Abused Women's Centre and this ex-police officer, for example, I don't think there's any option for him to, prove that he's going to do better, for example. I think that because he is who he is, he's able to get away with what has happened in this particular situation. I think that most of the stories that we hear, and I've referenced them in my speaking notes there, it's often that these men are in positions of power. I gave the example of the businessman in positions where they feel like they can get away with whatever they want. And what we know from the work that we do is the best predictor of future behavior is past behavior. And most of the time, it's as if our justice system is working on reaction instead of prevention. And so there's... Sorry,
Jennifer, I just don't have very much time, but there was lots of questions that I have because I want to go to Dr. Nicole Myers, because talking on this, when we're talking about the reverse onus of a C-75, do you support the reverse onus when it comes to those who have been sexually exploited and trafficked and domestic violence? What are your thoughts on that, if you don't mind sharing?
Certainly. Thank you very much for the question. I think the difficulty with reverse onus provisions is sort of speaking of them and trying to apply them to specific circumstances. That the Crown absolutely has the ability to make arguments for the detention of someone, whether they are the one that bears the onus or the accused person bears the onus. And what some of the difficulty then comes in is that when we think about this in a principled fashion and the difference in power between the state and an accused, is that if we're talking about denying somebody's liberty, that perhaps it should be up to the state to make those kinds of arguments.
I really appreciate that. I I think part of the problem that I have, though, and Emily, if you want to come in on this one too, part of the thing is we know that with abuse cases, that it's not just 1, 2, and 3 times that it continues. We unfortunately know that justice system is not always working. Unfortunately, we have seen some Bill C-233, hopefully that's going through, regarding judges training. We know sometimes these aren't taken into consideration. You mentioned about the 70.5% that are in pre-trial detention. Do you know what the data is on that, of how many of these are abusers of women and children?
This kind of data is not made widely available, unfortunately, for academic research.
Would it be possible for us to get data on that? Do you know if it's available?
I don't know. I mean, if you
Okay.
can, I think that would be fantastic. It's one of the biggest challenges we have is access to high quality systemic data to do those kinds of analyses.
Yeah, thank you very much. I think this, when I just look at this, the last thing we want is more women to be abused and constantly be re-abused by that abuser who has not gone through the justice system properly. So thank you very much.
Thank you, Ms. Vecchio. Saved by the bell. Next to Ms. Briard for 6 minutes.
Thank you, Mr. Chair, and I thank all our witnesses today for being with us. I will ask my questions in French, and the first one will be direct to Mrs. Cole. It's good to see you again. Pouvez-vous commenter?
Could you tell me about the impact of pretrial detention on the personal lives of women? And could you also tell us what that pretrial detention does to women who are mentally ill or addicted? Thank you.
Yeah, I think it is important to remember that among the people who are held in pretrial detention are people who have been harmed themselves hundreds, sometimes thousands of times over in their lives. And the harm that comes from being detained, and these are the people that we work with, is something that we don't often think about. So even being in detention and the impact that that has on very marginalized and vulnerable people's lives is something that isn't widely discussed. And so being in jail for even 2 weeks can impact a person's life in unimaginable ways. People who have been in pretrial detention for what some might consider very short periods of time can lose their employment, they lose their housing, and in the case of many parents that we work with, they lose custody of their children. As many of you know, in the federal system, there are half of the population of the people that we work with in the prisons designated for women are Indigenous women, and that number is higher in the provincial and territorial jails, particularly in the prairies. And so all of you are very aware of the efforts that we're making to address colonization in this country, and bail reform that places more people in pretrial detention actually has an adverse effect on our efforts to address colonization, because we have an epidemic of Indigenous children being taken away from their parents, and this is part of it. Because our bail system is part of a larger cycle of poverty, discrimination, and incarceration. And we think that that could largely be avoided with appropriate community supports and social services, which, as one of the other panel members suggested, prevention is key. The other thing to remember, if I may, or did you want to ask another question? I understand you have limited time.
Mental health and addictions.
Thank you. So, most of the people that we are working with suffer from substance abuse, and the issues that stem from that. The people who are imprisoned and go through the revolving door of the jail system are people who are often suspended or revoked on breaches that are related to a substance and the related poverty that comes with that, and then substance use and the related poverty that comes with that. And in addition to that, mental health disability is something that we see as prevalently within the prison system. We don't have enough services to support the people who have mental health disabilities in our communities. It would be beautiful if we did. And if we were studying that, and if we could put money towards that, that would really go a long way for preventing the harm of people.
Thanks. Merci beaucoup.
Thank you very much, Dr. Gwen. The GLADO principle helps take into account systemic racism and systemic discrimination against accused persons. Could you talk about the importance of those measures and explain how race and the criminal history of an accused influences a decision when it comes to bail decisions?
Thank you very much for the question. As we very well know, GLADO principles have historically been focused more so on the sentencing stage. And what we then sort of see is this desire to see a greater application for this at the bail stage. And while we want to think about how important it is that these provisions are meant to be remedial, that this is meant to target and address and understand our long-term colonial practices of over-policing and over-incarcerating indigenous people and all of the harms that flow from that. But I think the Supreme Court has also been quite clear that it is not meant to result in what might be colloquially called a get-out-of-jail-free card. That is not what is happening here. It is requiring a close analysis that is really considering the greater context and historical space of an individual so that we can make the most appropriate decision possible. And in wanting to bring those decisions into the bail stage, we see that they are just as applicable as they are at the sentencing stage because we are talking about people's liberty and the harms that then come from custodial time, whether that is spent pre-trial or post-sentence. I do apologize. I think there was a second half of your question that wasn't quite related to GLADO that you were asking me about.
Non, c'est ça.
No, that's right. I was asking about the race and the criminal record of an accused would influence bail decisions.
Criminal record is certainly one of the biggest things that are considered by the Crown when making their position on bail, as well as by the justice or judge making the decision on bail. You look at the seriousness of the current charges, the strength of the allegations, the criminal record that an individual has, and then we're balancing that with what the Supreme Court has said that we absolutely have to do, that we have to remember people are presumed innocent, that we have to remember that people are to be released unconditionally as our starting place.
Thank you, Ms. Brière. Next, we'll go to Monsieur Fortin for 6 minutes.
Merci, Monsieur le Président.
Thank you, Mr. Chair. My first question is for Ms. Coyle. Ms. Coyle, I understand your position, and I wonder what circumstances would be the kind of circumstances in which we should detain someone for a longer time. So what should be added as elements that would justify pre-trial detention?
I don't have any that should be added beyond what is currently there. I believe that when it comes to bail reform, we should be looking at making it less restrictive, not more restrictive.
Okay, donc,
All right. So now I have a question for Ms. Dunn, and I'll ask you the opposite question. So according to you, compared to the current situation, what circumstances are those in which someone should be released rather than keeping them in remand?
Thank you for the question. I think that I can speak specifically to some of the situations that women that we serve have explained to us. And so it's difficult because I had said this before to MP Vecchio that women should not have to look over their shoulder all of the time to go to the grocery store, to go to an appointment. We've had situations here at the center where a woman's perpetrator was, for example, sitting in the parking lot. This situation is a little bit different. He served his time and was released. But it seems like sometimes that doesn't matter. And so it's like, how far do we need to go to protect the victims in this type of situation? And we need to think about the victims on the other side when we're talking about crimes and we're talking about bail.
mais moi, je voudrais
Yes, but if I may, I'm sorry because I don't have a lot of time, but I would like you to ask the question that you just asked us. So, when could we better protect victims? Because the presumption of innocence is a principle that we all agree on, I imagine. So, right now, the rule is that someone is kept in pretrial detention when there's a chance that he or she won't be present at trial, or when public safety is in play. But you're telling us that they should be remanded more frequently, and I understand that because there are victims and there are cases of people who reoffend when they are on bail. But what are the circumstances? What should be changed in the legislation so that the victims that you mentioned to us can go about their business without being afraid of their aggressor reoffending? So how should the system be more severe when it comes to remand?
Thank you for your question. So I think we need to definitely look at all of this through a lens of violence against women. To be honest with you, we need to, and coming from where we come from and the work that we do, that is the answer that I can give. I know in this situation where I was speaking about the ex-police officer, so him being on bail now, for example, he has GPS tracking, and he's not allowed to use technology, situations like that. So perhaps, maybe, and we don't know because it didn't happen before, when this particular individual was on bail before, and then he ended up offending again and again. Perhaps some of those situations, if they were put into place first, such as GPS tracking or technology ban, may have been helpful toward the beginning. But in that exact situation, it had to get to the fourth charge before those types of things came into play. So I think that every situation is going to be different, and there's really no umbrella approach, if you will, when you're thinking about in this situation when you're talking about domestic violence, sexual assault, that kind of thing. Every situation is going to be completely different, so it's difficult to give you an umbrella.
I know. Désolé.
I'm sorry. I don't have very much time. I have less than a minute, and I wanted to ask Dr. Meyer, what do you think? I heard your testimony, and I understood that you were saying that the current rules are good, but there's Ms. Dunn who is telling us that we have to do more to protect victims. So how do you think we could add to the onus of proof to release someone, or what are the measures that could be taken to ensure the safety of victims?
Thank you very much. I think the challenge is that reverse onus situations are not going to be what's most effective. Nobody here is arguing against public safety, and we absolutely want to protect those who are most at risk from the most serious offenses. What we need to then do is focus on those cases and reduce the number of sort of minor or more or other types of cases that don't present the same kind of seriousness or risk, so we can focus our attention and resources on that which is most serious. And some of the other things we may want to do is look at how do we improve case processing to get people through the system so that we convict people and then sentence them appropriately, rather than trying to do everything on the front end. And so here it's then a matter of going, we want to protect people, but let's do this and think about this in a way that doesn't focus on specific incidences, but steps back and realizes that we have thousands and thousands and thousands of people in pretrial custody, and not everybody needs to be there. Let's focus on who's most serious and figure out how to intervene and let the others out.
Thank you. Thank you, Monsieur Fortin. Now to Mr. Garrison for 6 minutes.
Thank you very much, Mr. Chair, and thank you to all the witnesses for being with us today. I want to ask Ms. Coyle from Elizabeth Fry Society. I know Elizabeth Fry Society runs community supervised bail or community-based bail supervision programs. And as we're talking here that too many people end up in detention, and with all those negative impacts and the lack of services, could we tackle that problem by having additional resources devoted to community-based bail supervision programs?
Yes, is my short answer. A longer answer is that I'm being told that my internet is unstable. Can you hear me?
Yes, we can hear you, Ms. Coyle.
Oh, okay, good. So the CAPES network is made up of 23 local member societies all across the country. They do the essential on-the-ground work of supporting the most marginalized people in their communities, and many of them have bail beds, but most of them don't. So that's a problem. And we don't have Elizabeth Fry societies in the north of Canada. There are very few resources for people who could be released on bail into their communities in the north, particularly because those are people who may need a place to stay. They may need a bed to stay in order for them to be released on bail. It may surprise you to learn, actually, that there are only 4 bail beds for women in Canada's most populous city in Toronto. And those beds are available to Indigenous women only. And so for the most populous city to have no bail beds for women is a problem. And then if you go into the northern part of Ontario, for example, we have a couple of Elizabeth Fry societies who do have bail beds, but they don't have adequate resources to meet the demand. And so certainly more resources for bail beds would go a long way for the people that we were.
And so I guess I'll turn to Dr. Myers. In terms of contributing to public safety, there's certainly a perception from the public that people on bail aren't well enough supervised. But we put that also up against your very valid remarks that we could shorten the time before we convict people. That would help. But do you think that community supervised bail programs would help contribute to public safety and not just the perception of public safety?
I mean, I guess the short answer is yes. I think any effort to keep people in the community is what is going to give us better measures of public safety, restricting very closely those who need to stay in and letting others out, providing the kind of supervision and support that people may need. Nonetheless, I think we also need to be somewhat concerned about how some individuals may be over-surveilled or over-conditioned in the community that may be setting people up to fail, leading them to come back into the system. But again, this goes back to if we can restrict ourselves from bringing in so much minor matters, it allows us to best focus on that which is most serious and to monitor those folks in an effective manner.
And we see some data, I know as committee members and some of the stuff has been presented to us, the very high rates of breach of bail conditions. Can you talk about why that normally happens in terms of breach of conditions?
There's many difficulties around conditions of release. They tend to be very numerous. So, for example, on average, we're looking at 6 to 7 different conditions that create a brand new criminal offense once attached to a court order. And a lot of these conditions may not be being specifically tailored to individuals. Why? Because the courts are busy. They are overwhelmed by the sheer volume of individuals that they're having to manage and address. And so, again, wanting to take that time to be able to focus so that we can carefully craft conditions so that they are reasonable to comply with, but also being related to the grounds for detention as well as the allegations of the offense, rather than simply imposing conditions that we might like or that modify behavior that the Supreme Court has indicated is not what conditions are supposed to be doing.
And back to Ms. Coyle, in terms of conditions being imposed, C-75 was supposed to create this better link that Dr. Myers referred to between the conditions and the offenses and the reasons for detention. Do you find that on the ground, is that what's actually happening, or are we still having sort of blanket abstinence conditions imposed on people who have addiction problems, setting them up to fail? Is that still happening?
Yes, that still happens. And it goes back to an earlier question around how many people we are seeing entering the system due to mental health disability or substance use, which are connected undeniably in the work that we do. And I think social science will tell us that there's a reason that people with trauma and mental health disabilities use substances, because we don't have the resources to support them in their wellness journeys. And so, they are trying to deal with their pain in the only way that they can. And so, onerous conditions of release continue to be an issue as
Now you're having some technical
the overwhelming
difficulty.
number of in the bail just put out Inst Defense Council that works with our my apologies. What
No,
did
it's
you
good. It's good. It's
hear?
good. It caught up,
Did
so
you
you're
hear
good.
me? Okay. Oh, okay. I apologize. You would think in New York that the internet would be good, but apparently not. So I was just saying that one of the defense counsel that works with one of our Elizabeth Fry societies was saying that sometimes people are waiting up to 2 weeks in order to have bail hearing. And that I think is unacceptable. It's something that disrupts people's lives and sometimes irreparably.
Thank you. Thank you, Mr. Garrison. Next, we'll go to two 5-minute rounds, starting with Mr. Caputo for 5 minutes.
Thank you. And just out of the an abundance of transparency, my wife and Ms. Coyle do work for the same organization here, so I'll try not to fire any difficult questions there. But I do want to pick up on something, and I think we can all agree, and I'll just ask somebody to say yes. You know, when we're talking about somebody waiting for 2 weeks for a bail hearing, somebody has a constitutional right to go before a judge within 24 hours. I mean, Ms. Meyer, or sorry, Professor Myers, you would agree with that, right? So if somebody's waiting for 2 weeks, that's not typically on the prosecutor. I mean, a prosecutor can typically get a 3-day remand, but beyond that, that's a defense delay generally if we're waiting for 3 days or for 2 weeks. I don't know how that could possibly happen otherwise. You know, can you envision a scenario in which that's on the court or the Crown?
Yes, it is on the court and the Crown. Many of these adjournments are being requested for the purposes of getting defense counsel, but mostly because people want to secure a consent release, understandably, rather than going to a show cause hearing. And the Crown's the driver of the decision-making process in bail, mandating that individuals need to have a surety, or they need to have bail program, or there's a variety of conditions that they need to be able to meet. So often that these adjournments are then happening for individuals to either secure legal counsel to represent them at the hearing, or to try to put together the kind of bail plan that is going to meet what the Crown is indeed seeking. So yes, the adjournments are, study over study indicates most of them are coming from the defense or for them the accused, but those reasons for the adjournment are to meet the demands that the Crown is putting forward.
But that's only problematic if the demands of the Crown are themselves unreasonable.
Yes.
You'd agree with that?
I would agree.
So if we have a properly functioning system, then you know, the system, a number of the issues that are highlighting aren't as problematic. Now, we can all agree, and I think all the witnesses would agree here, public safety is paramount. Can we all agree that that's the number one issue? All the witnesses? I hope so. I would hope that we can. So, and we also have this idea as well that, and some of the witnesses today have highlighted it, that we're talking about different, I'll say, calibers of people who fill the courtroom. There are people who, you know, in my experience, they don't belong in court, right? They walk through those doors, they may have made a mistake, they may have made a few mistakes, but court is not home for them. Do you get what I mean by that? It's not a friendly environment. Do you understand that? I'll look to you, Professor, because you're here.
Yes, yes, I think we can agree.
Certainly. And then, you know, in a town like my hometown of Kamloops, it's a city of about 100,000 people, there are a very small group of people, and sometimes, well, I think most of the time we can agree, that particularly when it comes to violent crime, a very small group of people disproportionately commit a number of the offenses. Would you agree with that as well, Professor?
I believe that's what the empirical evidence demonstrates, yes.
Certainly. So if we accept that conclusion, we have to target bail at that small group of people. That's a fair assumption?
I think that would be a reasonable way to go forward.
Okay. So where a number of people will probably part company, I think, on this thought, is where that dangerous group comes in. Would you agree with that then?
Yes, it's very difficult to identify who those people are with accuracy.
It's difficult to identify with accuracy, but there are some objective indicators, and when you look at people, and I think you would probably agree with this as well. The best predictor of future behavior is past behavior, though it's not a 100% predictor, and you will never get a 100% predictor. Is that accurate?
It is. It depends on our comfort level then of getting it wrong and incarcerating people that should not be incarcerated.
Or getting it wrong and having somebody potentially grievously harm somebody else, because that's the flip side. If you have a dangerous firearms offender and you get it wrong on the release end, the consequence could be that somebody's shot. So it's not just a matter of getting it wrong on the one side and somebody's in custody. There's also a flip side of getting it wrong and somebody's harmed. You
Absolutely.
Oh.
That can also happen after they've been convicted and sentenced.
100%, but after conviction and sentence, there is no ability for the state to control. Do you see what I mean?
I completely understand.
Okay.
I'm just saying at that point we've proven it.
So I'm sorry? Oh, okay. Oh, sorry, Emily, or Ms. Coyle, I'm sorry. Please go ahead.
Thank you so much. I just wanted to say, when we are talking about public safety, in the line of work that we do, we have to remember that the people that we work with and alongside, who are the many people who are criminalized, the women and gender diverse folks who are often in prison, they're part of the public when we're talking about public safety. And merely saying that putting someone in custody, as an aside, is actually there's a lot more to that simple statement. And, we are concerned about people doing irreparable harm. And we're concerned about the state doing irreparable harm. And that's a really key point for us, because if somebody is put in prison or in jail, and they have been wrongfully convicted, and there are many examples of that in our country that we know, and many that are there that we are aware of that are not public, then the state has done irreparable harm in that case. But
Thank you.
Jail for 2 weeks is hard, on people's lives.
I don't disagree. I can tell you this: when I was a defense lawyer, I had a case that I believed was a wrongful conviction, and it still keeps me up at night. So you're not going to get any argument here from anybody about that. It's my time is up, so I'll stop.
Thank you, Mr. Caputo. Next, we'll go to Mr. Nakvi for 5 minutes.
Thank you very much, Mr. Chair, and I want to thank all the three witnesses for being here and presenting to us. I'm going to direct my questions to Dr. Myers and Ms. Quayle, and I'll ask the same two questions because I just want to very clearly understand your perception as and your analysis based on your experience as we study our bail system. And my first question, I'll start with Dr. Myers, with you, is what do you perceive as the challenges we face in Canada within our bail system at the moment, and perhaps both in practice and legally?
Thank you for the question. I think we face a variety of issues. It's not something that has sort of a single answer to it, that we bring far too many minor matters into the court system to begin with, and that some of this could be resolved by encouraging the police to exercise their powers of release, to use the judicial referral hearings that, for at least anecdotally, have not been used in a widespread manner. We also have difficulties of a risk-averse mentality in court. And this is an understandable mentality because when incidents like this happen, when police officers are killed by somebody who is out on bail, or allegedly at the time, that we are deeply concerned about the violence that women experience, that we are understandably concerned about what happens to victims. Yet we nonetheless have to step back and think about how do we best achieve safety for those individuals. And holding more people in custody, releasing people with conditions they have no reasonable prospect of complying with, is not going to enhance our public safety. Being mindful that we have a sort of a limited means to what we can do at the front end of the system, because we have to hold at its center that we presume people innocent, that you have a right to reasonable bail, and that bail is supposed to be unconditional. Yes, pardon me.
That's great. Thank you. And if you can also then briefly share with us your recommendations to this committee as we study the matter of bail. If we were to make changes, what would be some of your top 2 or 3 recommendations?
Absolutely. I think providing better, clear guidance and direction to decision makers about what we want them to be thinking about and focusing on when they're exercising their discretion. I think we might also want to consider what might look like hurdles to custody, something similar that we see in the YCJA, and not acknowledging that, of course, young people are different than adults, but thinking about who do we want to be holding in custody and who do we want to be letting out? So, for example, perhaps we want to try to focus our attention on those who've been charged with particularly serious offenses and have a criminal record that demonstrates a pattern of behavior of that kind. Maybe we want to think about people, what is the likely sentence that they would receive if they were convicted? And if it's less than 6 months in custody, that we should be presumptively releasing them into the community. And for those who are charged with failing to comply with the condition of their release, to look, did they commit a new substantive offense at the same time? time, or that condition of release, did it cause harm to an identifiable victim? The other thing that we might want to think about is how do we provide the best level of support for people in the community? If we know that that is not only less expensive, but that helps make it less likely that people are going to commit offenses. How do we support individuals? How do we support communities so that people can stay in the community, maintain their ties to the community, their investment in the community, making it less rather than more likely that they'll commit more offenses?
Thank you very much. Not seeing the chair right now, so I don't know how much time I have, but Ms.
You have a minute and a half.
Great, thank you, Chair. So, Ms. Qualvic, a minute and a half, I have the same two questions. Through your experience working with Elizabeth Fry Societies, can you share with us what you see are challenges with currently with our bail system in Canada, both from a legal perspective and practically, and what are your recommendations for this committee? Thank you.
I think beyond what Dr. Myers has said, because I think that she's put it really well. I am concerned about access to legal aid. I'm concerned about access to adequate representation, obviously, for the people that we work with. And I think practically speaking, where I always come back to is investment in upstream resourcing of communities, supporting people who are experiencing poverty, ensuring that precarious housing is something that people are not being punished for when it comes to bail, enhancing social welfare supports, increasing investments in education and healthcare, essentially just keeping people in the community and ensuring that they have the supports necessary so that they don't experience the complete uprooting that happens when they're put into the jail, even for a short period of time.
Thank you.
I think my time is up.
Yes, thank you, Mr. Naqvi. Next, we'll go for two quick 2.5-minute rounds with Monsieur Fortin for 2.5 minutes.
Merci, Monsieur le Président.
Thank you, Mr. Chair. Dr. Myers, at the beginning of your testimony, you were telling us about the proportion of people who were detained before their trial. So you said there was more than 70% of people who were in pretrial detention. Is that right? So what is the exact number?
The individuals is 14,400.
Non, le pourcentage?
70.5 across Canada.
Et ça, c'est au Canada.
And that's in Canada or just in Ontario? Okay, throughout Canada.
Ontario sits at about 77%.
Okay, merci. Et je vais vous...
Thank you. And so I will ask you, again, what I asked earlier, that you were talking about how we should focus efforts and how to sort of focus on the severity of charges. So we have to find a balance between protecting victims properly and avoiding, on the other hand, having somebody who is not guilty being behind bars. So how can we reconcile those two things? You are saying that perhaps the way to do it is to focus on the severity of the accusations, but we know that just because somebody is charged or accused of a severe crime, it doesn't mean that they're guilty, because there are innocent people who are accused of severe crimes or offenses. So what should our focus be? What should we look at, and what should we change in the current legislation to better protect victims and avoid judicial error?
I think providing clear direction and guidance for exactly how we want decision makers to make that decision. Where do we draw these lines? And I don't think that it's easy about where these lines are precisely drawn. And I have a lot of hesitation of arguing for wanting to hold more people in pretrial or releasing people with more conditions. That is in itself problematic. But if we have to think about, again, where we draw the lines is how it is we identify and focus on those who are indeed most serious. And I don't think there's an easy or clear way to identify who those people are.
Donc, cette...
So the line that has to be drawn, you can't really tell us where we can draw it. That's what I'm understanding from what you say. Because our problem is not an easy problem to solve. That's what I understand. So I have perhaps the same question for Ms. Coyle. Where do we draw the line? How do we protect victims and avoid judicial error?
Your time is here. Monsieur Fontaine is up. Mr. Garrison for 2.5 minutes.
Thank you very much, Mr. Chair. I think perhaps we got a little bit of distortion today in talking about the time for a bail hearing. when the numbers show that obviously people are in custody sometimes a very long time before the trial process. So I wonder, Dr. Myers, if you have any figures or estimates on time people are spending between that bail hearing where they're obviously being denied bail and the trial process.
Unfortunately, I don't have the numbers right in front of me, but often we're looking at the time between arrest and the resolution of charges sitting at somewhere over 100 days. Again, this is on average. And so when we think of those who are in pretrial detention, you have a small number of people that are going to be there for a very long time who may take a year or 2 years to come to trial. We also have a lot of people who are going to spend very short periods of time there because we have what I've called a culture of adjournment in bail court, where each and every day the most likely outcome across this country is that your bail hearing is going to be adjourned to another day. And so we make very few actual bail decisions each and every day. So a lot of the people we're seeing in remand are sort of in this churning place. They may eventually be released, but they are going to spend time in custody first. And as we've talked about, as well as Emily has spoken about, there are incredible harms that flow from even short periods of time in custody, making it more likely that people will offend rather than less.
And for the last minute, I suppose, back to Ms. Coyle, in terms of services available to people who are in remand, just to make it clear again, I think before the committee and on the record, that those with addiction, substance abuse problems, those with mental health problems really don't have access to services during that time period while they're waiting for trial. Would that be true? I'll go to Ms. Coyle.
That is correct. Yes.
Public safety
And
then?
I just want, pardon me?
So that becomes problematic for public safety in the long run.
Oh, yeah, certainly. As people are coming, off of whatever substance that they may be addicted to, it's harmful to their own safety. As I said, there are many people who have been dying in our jails, in our territorial and our provincial jails, and there hasn't been a public outcry about that. I am concerned about the fact that families and loved ones of people who've been dying in our jails, many of them on pretrial detention, that hasn't warranted a study, a committee. People aren't raising the alarm about that, and they should be. There have been vigils held, there have been podcasts made, there have been op-eds written, and certainly our government should be paying attention to that because it is, indicative of a much larger problem.
Thank you, Mr.
Thank you.
Now we'll thank you to all three of the witnesses. That concludes our first panel. So we'll now suspend while we set up for the second panel. And thank you once again for appearing, and many of you for the second or third time. Thank you.
Thank you so much.
continue our study on Canada's bail system for the second hour. I hope the witness online has heard or seen my little note card, so that's about it. And then you've been already tested as to sound, I believe, and hopefully for translation purposes, you've selected the correct feature, whether it's the floor, English, or French. So you have that, and I advise the same to the witnesses here. If you want to adjust your, put your headsets and you can pick which channel you want to listen to. Each of you will have 5 minutes, and we have Dr. Donardo Jones, Assistant Professor, Faculty of Law, University of Windsor. Welcome. We also have from the Families for Justice, Marquita Colas, President, and I think she's via video conference. And we have Leah Vilestra, Bail Court Support Worker from Victim Services of Brent, and you're here in person. So we'll begin by Dr. Donardo Jones for 5 minutes.
I should correct the record. I'm a PhD candidate, so not quite a doctor yet, but very soon.
Thank you.
It does sound nice, though, the ring of. So thank you for the opportunity to be here today and to participate in the study on Canada's bail regime. I have 3 points that I wanted to make today before taking your questions. One, bail is a constitutional right. Right? It finds its expression under Section 11E of the Canadian Charter of Rights and Freedoms. But bail has also been a part of the common law system for centuries. This is not a novel idea. It's not something that came into existence in 1982. It's been a part of the common law tradition for a very long time. It recognizes that the state has a burden of establishing an accused person's guilt before denying or abridging their right to liberty. So the right to bail subsumes other constitutional imperatives, for instance, the presumption of innocence, the right to life, liberty, security of the person, and the right to a fair trial. But taken together, all these constitutional rights, they form perhaps the strongest procedural safeguards for people accused of criminal offenses. I mention this to set the tone that we have to be careful that in protecting public safety, which is important, which is paramount, it doesn't come at the loss of public confidence in the administration of justice. It doesn't come at the loss of an erosion of constitutional rights. Now, my second point is that the granting of bail is not a matter of judicial benevolence or leniency. It never has been. I make this point because in our criminal jurisprudence on bail, the presumption in the criminal code and also in the case law is release. There's a reason for that, because accused people are presumed to be innocent. The Supreme Court of Canada has said over and over again that the granting of bail should not consider matters extraneous to the requirements articulated in the criminal code and also in the jurisprudence on judicial interim release. Bail is about risk management. It's not a science, it's an art. There are factors that are considered, that are set out in the criminal code that a bail judge or a justice of the peace must consider in their decision making. But we're also reminded that the principle of restraint is paramount. The idea that we should not rely or over-rely on carceral responses at the bail stage. And there's a reason for that. We cannot compensate people for the loss of liberty after they're acquitted, or a prosecution fall apart, which often happens. These people cannot be compensated. I've heard a few witnesses talk about some of the collateral consequences of being denied bail or being granted bail but on onerous conditions, whether it's loss of job, whether it's disruption in family life, and so on. And to my third point, I wanted to talk about one of the reasons why people do poorly on bail. It's not because these people are inherently risky. There's a lack in social infrastructure that allow people to thrive while they are out in the community waiting for their day in court. Oftentimes, that is the reason why people breach. Lack of housing, inadequate access to treatment, inadequate access to the things necessary to lead a pro-social life. Thank you.
Thank you, Mr. Jones. And next we'll go to Marquita Collis from Families of Justice.
Thank you very much for inviting me to be here today. On December 27th, 2002, the killing of an Ontario provincial police officer brings renewed scrutiny to Canada's bail system. And following the shooting death of Constable Greg Pachella in Ontario, the 25-year-old suspect, Randall McKenzie, was wanted by police for missing an August court date. He was accused of assault, and he had a number of weapons charges. A judge issued a warrant for Mr. McKenzie's arrest when he failed to show up for a court date. Mr. McKenzie had a previous lifetime firearms ban after being convicted for a 2017 armed robbery. He spent much of his nearly 3-year sentence in maximum security for allegedly stabbing another inmate. While out on bail for charges of assaulting another police officer and illegally possessing a handgun, Randall McKenzie is now facing a charge of first-degree murder in the death of Constable Pachella. There have been 6 police officers killed across Canada in the line of duty in the last few months, and the Canadian public and several police agencies have great concern and demand new bail reforms. On January 13th, 2023, premiers across Canada issued a call to action, strongly asking the federal government to take immediate action to strengthen Canada's bail reforms. The call for bail reforms is supported by several police agencies. In addition, you have millions of Canadians who are asking for bail reforms and demanding tougher sentencing laws in Canada. We believe that the rights of the accused are being prioritized over the rights of victims and public safety. The criminal justice system fundamentally needs to keep anyone who poses a dangerous threat to public safety off the streets. And this starts with meaningful changes to the criminal code, an area solely within the federal government's jurisdiction. Most Canadians are feeling enough is enough. We cannot allow the deaths of police officers or innocent people to go unchallenged. And as elected government officials, it is a priority to review the judicial and public safety frameworks, commit to fully understand their best remedies, identify what isn't working, and call for change to ensure that this does not continue. Everything should be on the table, from bail to sentencing to a growing number of chronic shortage of police officers. In BC recently, stats showed that 200 people accounted for more than 11,000 police files in just 1 year. Our police agencies also flagged a significant increase in the number of offenders routinely breaching conditions without consequence while out on bail and failing to appear to court without any consequences. The urgent call for stronger bail conditions, stricter consequences in sentencing, as well as stronger consideration for maintaining public confidence in the administration of justice in bail and charge assessment policies is long overdue. And recently in BC, since 2017, there's been a 118% increase in the amount of time the province takes to review files it receives from the police, and a 75% increase in the rate of the BC Prosecution Service choosing to not charge suspects on police file cases. We have a criminal justice system that is not working, and it hasn't been working for years. Most Canadians, when asked to consider our criminal justice system, refer to the system as a joke, based on the lack of appropriate sentences handed down for serious crimes. And these sentences are based on previous court precedents. This includes impaired driving cases, stalking, domestic violence, and homicide cases. Bill 75, a federal bill passed in 2019, was designated in part to modernize and streamline bail procedures. However, it is inadvertently causing more repeat offenders to end up on the streets. We now see an easy catch and release bail policies, which makes it easier to get bail. And we seem to have a revolving door at the courthouse. The accused who has been arrested, who have a long rap sheet for previous offenses or violent crimes, or they're prolific offenders who continue to commit crimes knowing not much will happen to them in court. In Canada, they are being released again and again and again, and are being given a minimal sentence, if any at all. And Canadians believe if convicted, a person should stay. Time is explained to the public. Ensuring the safety and security of victims and witnesses should be an essential part of the decision-making process in release procedures. We would like to see a legislative bill reform that gives more weight to those that we deem as chronic offenders, those who have demonstrated a repeat pattern of violent behavior and behaviors with firearms, and the actions caused by involvement due to being impaired by alcohol or drugs. Previous criminal history should play a large part in determining if bail is granted. On behalf of all victims of crime, I call upon this Justice and Human Rights Committee and the Federal Government of Canada to make the needed strengthened changes to Canada's bail reforms to ensure that public safety for all Canadians. Thank you.
Thank you. Now we'll go to Ms. Vliestra for 5 minutes.
Good afternoon. Thank you all for your time and allowing me this opportunity to present to you on the issue of bail reform. It is an issue that's having a significant impact in Ontario. I'm hopeful that positive changes will be made to better protect victims and communities as a result of this inquiry. My name is Leah Vliestra, and I have provided support to victims for the past 10 years in my role as bail court support worker at Victim Services of Brant. My position is funded through the Brant United Way, and our office is located at the Brantford Police Station and assists clients for the City of Brantford, Brant County, and 6 nations of the Grand River. As part of my role in bail court, I will contact victims who offenders are appearing in bail court and obtain input from the client regarding their safety concerns and other information they would like provided to the court. I then send their input into the Crown to consider when taking a bail position and proposing conditions to the court prior to the accused release on bail. While speaking to the victim, I conduct a risk and needs assessment for urgent resources that the client may need immediately in the case the offender is released on bail. For example, a lock change and safety planning. Following the bail hearing, I will notify the victim of the bail conditions and offer further supports. This role has become challenging in recent years due to the volume of arrests in bail court and how quickly offenders are released. This is particularly apparent when it comes to intimate partner violence. We can face difficulty even being able to have a locksmith attend to change the locks before the accused is released on bail with nothing more than their own word to abide by conditions. Notifying the victim as soon as possible of a release can become critically important. I have had to call 911 while being on the phone with a victim of intimate partner violence because the accused came through her door 10 minutes after being released on bail while on conditions of no contact. This is the unfortunate reality of our bail system. It has become a one-size-fits-all based on the ladder of release since the Supreme Court decision R versus Antic in 2017. Currently, you can be charged with domestic violence, sexual assault, robbery, and released on the same form of release as someone charged with mischief and theft under. Changes that I believe need to be made for public safety and public confidence in the bail system are the following. Violent repeat offenders should be denied bail. Drug trafficking, especially fentanyl and meth, should be denied bail. If you are charged with using a firearm, you should be denied bail. The use of more cash bail and bailish treatment for those convicted of breaching their bail conditions should be escheated for the entire bail amount. Sureties need to be thoroughly vetted regarding their ability to supervise and their financial assets. In the case of intimate partner violence, the surety for the accused should not be a new intimate partner. Bail conditions need to be put in place to address the risk factors relating to the specifics of each case. For example, if an offender is only coming before the court when they are intoxicated, conditions of supervision and support need to be put in place to address alcohol as a risk factor, especially if the charges involve violence. Stronger conditions relating to victim safety must be put in place. In Brantford, it is common for the court to only impose a 50-meter radius from the victim's residence or employment. This is approximately 2 residential houses apart and can allow for the accused to live on the same block as the victim. In cases of criminal harassment and stalking where the accused has no reason to be in the city where the victim resides, a geographical radius for the entire city should be imposed. There have been cases where this was requested and the condition was not imposed because it was too onerous on the accused. Tertiary grounds should also be taken into consideration in cases where the accused has an extensive criminal record. That goes to the heart of one of the prongs in the assessment on the tertiary grounds, which is the public confidence in the administration of justice. Bail supervision programs should not be used as a form of supervision in cases of violence, and particularly intimate partner violence. They do wonderful work, but they cannot provide the supervision necessary to alleviate the concerns on the secondary grounds. Supports for offenders. Much of the input that I receive from offenders, family members, and intimate partners is that they want the offenders to receive the help they need. Whether it's for addictions or mental health, they want them to have a place to live where they can receive their medication, receive their mental health assessments, counseling, and treatment. Unfortunately, this does not happen in bail court. Once a justice of the peace conducts an assessment under Section 493 and determines that the accused belongs to a vulnerable population, they must look to alternatives to incarceration. This can usually result in the release on their own recognizance or to the bail supervision program. More needs to be done for low-level offenders struggling with addictions and mental health at the bail stage. By the time they are placed on a probation order, they can have up to 10 sets of charges. Thank you for your attention, and I'm open to any questions.
Our first round of 6 minutes with Mr. Van Popta.
Good. Thank you, Chair, and thank you to all the witnesses. I'll start with you, Ms. Collius. It's nice to see a familiar face from British Columbia, and thank you for being here, giving evidence, and for the important work that you're doing with your organization. And I know that you work a lot with the victims of impaired driving, and I know you've done some very, very effective work there. So my question is going to be about that, and particularly about repeat offenders, repeat impaired driving offenders, and just maybe share with the committee your experience around that and how that might tie into bail reform.
Well, we've seen too many times, as well. It's not a first offense. Usually, police have told us they usually, for every 100. For every person they stop that is impaired, 100 more get away, and we continue to see the stats rise. And we have had, repeat offenders who have had 3 and 4 and 5 impaired driving charges against them. They're released on bail, and then as well until they finally kill someone. And even then, the sentences, we've seen sentences of, $1,500 fine, $2,000 fine. We just had 2 cases here in BC last week. And the people who were convicted of killing someone received house arrest. That's no deterrent to stop drinking and driving. I'm sorry, it's not. Those families were left devastated to know that the individuals who killed their family members are just back home, continuing on with life. They may not be going outside, but they are not spending any time in jail whatsoever.
We're talking about bail reform in this study. So I'm going to ask a question specific to that. Do you think that it would be fair to make abstinence from alcohol a condition for granting bail to a person charged with impaired driving?
Absolutely. We need to do something. I mean, we're losing over 10,000, about 1,500 people a year to impaired driving. And I don't know what it comes down. I mean, I have been fighting for change now for 12 years. And there's still so much more that needs to be done because we continue to lose people. And I don't know whether it's going after the car manufacturers to implement something that the car will not start, like an interlock ignition. I don't know whether it will be tougher sentencing laws or whether it will be that it's you get one chance to get your license. And if you drive impaired and if you crash and kill someone, then you lose your license. It's gone forever. It's something that has to be tough. It has to be drastic, but people have to know if they can drink and drive and cause a collision that kills someone, there are severe consequences to those actions.
Okay, good. Thank you for that.
I think it's.
Thank you. Ms. Fleistra, I'm going to go to you. Thank you for the evidence that you've given. You said that you would, if I understood you correctly, recommend an outright denial of bail for repeat violent offenders, drug offenses, and for firearms offenses. Did I understand that correctly?
Yes.
Okay, so now earlier evidence that we heard today from Dr. Myers, I think it was that there's a very, very high percentage of people in incarceration who haven't been convicted yet. And so these are people who are awaiting bail. So by denying more people bail, that's just going to increase that population. So what do you say about that?
The people that are in custody that I see are not being denied bail. They're in custody at the defense's request for an adjournment. Some may be in a bail set not met position, but most requests are remand at their lawyer's request for different reasons that I wouldn't know.
So you don't see that bail reform, either making things stricter or less strict, is going to make a difference because it's really just procedural in court that is slowing bail courts?
Well, if more people were denied bail, that would result in more people being remanded after being denied bail. But currently, right now, from what I see, people are not being remanded as a result of being denied bail.
Okay, good. Thank you. Mr. Bernardo Jones, nice to have you here. We had, earlier in the study, we had Chief Darren Montour here of the Six Nations Police Force. And that was the police service that was supervising the bail conditions of the person who is now charged with murdering Greg Pershella. And Chief Montour made the point that that there are deep societal problems that are underlying the whole issue of bail and our judicial system. But this is the way he ended that statement. He said, "It is sad to say, but we still have a responsibility," and he's talking about the justice system, "to ensure public safety of our communities because 99% of the time the offender is indigenous and so is the victim." So my question to you is, how do we resolve the tension between not wanting to further harm those? I'm out of time.
Yes.
And ensuring public safety. Maybe you can have a chance at that later.
Next, we'll go, sorry, Mr. Van Popto, we'll go to Ms. Diab for 6 minutes, and then hopefully you can answer that question later.
Sure. Thanks very much, Mr. Chair, and welcome to our witnesses. Very much appreciate you all coming to help us parliamentarians do our job in trying to figure out what the challenges are in the bail system and what recommendations you have. I'm going to start with Mr. Jones, and I'm going to actually, on the same theme that has just been asked that you didn't have a chance to ask. On the Gladue principles, I would ask you to please comment on the importance of these measures and the consideration of an accused's race and background generally in the bail system, but also in your research experience. How are these Gladue factors and other elements of the accused background weighed compared to other factors in bail decisions?
Thank you for that question. So we know that race is an extremely important consideration in who gets bail, on what conditions, and who's able to meet whatever conditions are set, whether it's by the Crown or by a judge or a justice of the peace. As I mentioned in my interlude, bail is all about risk management, and risk is read on bodies. Certain bodies read as more risky than others. There's a tremendous amount of sociological data to support that. This is not something that our courts, that's lost on our courts. Our courts actually, the Supreme Court of Canada, the Court of Appeal, routinely reminds lower court judges to take judicial notice of this fact. So, Gladue factors play a role in that it reminds bail jurists that the opportunities that most non-Indigenous people, non-racialized people, particularly Black accused people, the opportunities that they would have are not opportunities that are afforded to these folks. Unfortunately, it is these folks that are overcharged, and it's these people that find themselves before our bail courts. So taking race into consideration does one of two things. It either levels the playing field, so our system is more fair, or at the very least, it creates a contextual background to allow a Crown or a Justice of the Peace to make an informed decision about whether or not this person is too risky to be released pre-trial. So that is it. It is just about providing necessary context to allow a Justice of the Peace or a judge to make a decision around risk.
Thank you for that. What would you say to provinces and territories? What can they do to contemplate the federal government's action on bail?
Well, judicial...
Sorry.
Sorry?
To complement the federal government's action on bail.
Well, judicial education is important. Having judges understand that because we're asking judges or justice of the peace to take race into consideration, it's not necessarily an act of leniency or some kind of discount. That's not the case. It's providing the necessary context, the social context that is required for decision makers to make fair decisions, decisions that are in line with our constitutional values. It's not possible to make these decisions without taking that context into consideration. So it means our crowns need to be educated about some of the implications of race, and also our bail jurists, whether it's a justice of the peace or a judge. It's that necessary context that is missing.
Thank you for that. Can you describe what C-75 did in your experience and the impact it had on the bail system?
It provided bail jurists, crowns, and defense lawyers with language that was missing from our judicial interim release provisions. For example, the principle of restraint, bringing in considerations for vulnerable populations, including Indigenous populations. That was something that was missing from bail provisions. So it provided the necessary language. It provided that vocabulary, right? So we know that the Supreme Court of Canada has said that whenever Indigenous liberty is at stake or is at issue, Gladue principle will always apply. Unfortunately, there was no jurisprudential guidance around whether or not anti-Blackness or the plights of Black Canadians should, form the basis or at least be taken into consideration at the bail stage. 493.2 gave that language, that vocabulary.
Thank you, Ms.
Thank
Diab.
you. And Chair, am I?
Yes, you're out of
Am I
time.
hearing you?
Thank you, Ms. Diab.
Thank you very much, and best of luck to you, candidate for PhD.
Thank you very much.
Thank you. Next to Monsieur Fortin for 6 minutes.
Merci, Monsieur le Président.
Thank you, Mr. Chair, and thank you to the witnesses who are here with us. So, Mr. Jones, I would like to hear you on a certain topic because we are looking into the provisions for bail and we are listening to testimony that tells us that there are too many people who are released on bail too easily. But then we have other people who tell us that no, there are too many people who are detained pre-trial, and there should be fewer. Someone earlier told us that over 70% of detained persons are there pre-trial, which seems quite surprising to me. But at the same time, when I hear about the situation of victims who see their attacker being freed on bail and then repeat the offense, well, that's a very difficult thing as well. So where can we draw the line? How can we avoid putting victims in danger or prevent repeat offenders who are out on bail from committing another crime, on the one hand, and then on the other hand, avoid keeping innocent people in prison when they haven't had their trial yet? So how can we balance those interests?
Thank you for that question. So going back to my earlier comment about risk management and sometimes the difficulty around calibrating what is the appropriate approach to balancing those two very important considerations, public safety on the one hand and constitutional values on the other. As I said, it's not a science, it's an art. And it requires crowns and also bail jurists to exercise common sense, right? And also to be alive to, as I said, the necessary social context, right? So we understand that we don't want people who pose a tremendous risk. The language used in the code is substantial risk. So how do we determine whether or not this person poses a substantial risk of reoffending, right? So the code gives us some guidance. It tells us about antecedents, whether or not this person committed other offenses or have convictions. Also, it tells us about the type of offense. So the normative kind of dimension of the offense. So if we're talking about a serious violent offense and so on, these are considerations that a bail jurist will take into consideration in making a decision.
Seriez-vous d'accord avec Madame Viestre?
Would you agree with Ms. Viestra, who said that when there has been a violent reoffender or a firearm offense, then bail should be denied?
I categorically disagree with that. That is an affront to our Constitution.
Et rapidement,
Quickly then, I may have 2 minutes left. You talked about the effect of Bill C-75 on release on bail, but I'd like to hear about the effect of the abolishing of mandatory minimums, whether that had an effect on release on bail. Did it change anything with regard to a judge's decision with regard to the severity of an accusation?
Well, mandatory minimums, if they offend Section 12 of the charter, the courts have struck them down. Really, what courts are saying is that they are well positioned to sentence an accused or sentence them to a proportional sentence. They have the necessary experience to do that. Mandatory minimums remove that discretion.
Je m'excuse, je veux pas être
Sorry, I don't want to interrupt you and be impolite, but I don't have very much time. Yes. So my question has to do with the signaling that takes place. So I also agree that the judge should decide what sentence should be applied because I think that they have 99.9% of judges are there and do an exceptional work. So I have no problem with that. But when the lawmaker says we are going to abolish mandatory minimums, a message is sent to society, and I'm wondering about the scope of that message and that signal because it could be interpreted as saying, listen, that offense is not that serious. So I'm asking you whether that message about the severity of crimes has an impact on the decisions about bail.
I wouldn't say it has an impact on what decisions are made in a bail court. One, because there's different considerations that are being taken that are being looked at the sentencing phase. We're talking about proportionality. We're talking about just desserts. What is a proportionate sentence, right? That's what we're taking into consideration. Gravity of the offense, moral blameworthiness of the offender, right? So we're taking that into consideration. You raise a point around the communicative dimension of a sentence. What message is it sending to the public, right? Is it saying that this particular offense or behavior is not serious? And if a mandatory minimum is not attached to it, what I'm suggesting to you is that our courts are well positioned to send a message, whether it's a message of deterrence or denunciation, right, to attach a penalty that articulates society's, abhorrence of a particular conduct. Our courts are well positioned to do that. I don't think our courts have been handing down lenient sentences that send a message to, prospective criminals that, they can, commit crimes with impunity. I don't think that's what's happening with the removal of mandatory minimum sentences.
Thank you, Monsieur Fortin.
Thank you.
Garrison for 6 minutes.
Thank you very much, Mr. Chair. I want to continue with Mr. Jones. I want to back up a step. I think you made your 3 points. You didn't get a chance to kind of summarize what that meant, and I'm guessing that you're going to agree that the bail system contributes to the over-incarceration of marginalized, racialized Canadians. And I want to give you a chance to talk about how that happens.
Indeed. So we know from the social science data that police officers engage in racial profiling. I think at this point in time, that's not a very controversial, statement to make. What that results in is an over-prosecution of racialized people, Indigenous and Black people. When these people are in bail court, as I said earlier, because of how we read risk and how risk is kind of inscribed on bodies, these people are, whether it is the Crown's onus or it's a reverse onus, they're seen as less likely to adhere to whatever bail condition they would, someone not in their position would have received. Because we have certain narratives around who is more trustworthy. And that is the threshold for evidence in a bail hearing, credible and trustworthy evidence. Some people, because of certain, as I said, racial narratives, are deemed to be more credible, more trustworthy. And we're not just talking about the accused person, but also any sureties that they may rely on, right? So there's a profound issue with how risk is understood and how we, as I said, read risk on particular bodies. This is where that, as I said, race kind of sensitivity or, awareness or consciousness comes into play. Is that something that you can legislate? Not necessarily. As I said, I think Bill C-75 gave us some language, but it is incumbent on Crowns and defense lawyers and JPs and judges to start taking notice of some of these, as I said, realities on the ground, racial realities on the ground, and incorporate that into their decision making.
And I think earlier you talked about what leads to breaches of conditions. And I guess I'm going to ask you a similar question. It seems in the literature that people who are racialized, otherwise marginalized or indigenous get more conditions, and then they're more likely to be unable to meet those conditions if they're on bail. And I'm presuming you're going to tell us the same thing. So, there's a reason for that.
So indeed, we've seen that the bail system, unfortunately, has been almost co-opted to be used as some kind of proxy for punishment. That's a perversion of the bail system. And it's also an affront to our Constitution, an affront to Section 11E, definitely. So it is this, attempt, I think, to turn bail hearings into proto-trials, a trial before a trial, right? Which is, as I said, which is worrying because there's different issues being decided at a bail hearing. As I said, it's about risk management. It's not about proving guilt or innocence, and it's also not about punishing people for wrongdoing, right? That will happen later on down, right? We cannot, as I said, co-opt or circumvent the process to try to punish people earlier because we believe, as I said, we think it's already a foregone thought or conclusion, I should say, that this person is guilty. We don't know that. That's the reason why we have an adversarial system. One day, the person will have their fair trial, and that determination will be made.
I have 1 minute left. Can I go back to when in your original presentation, you talked about the inability to compensate for the loss of liberty. Can you say a bit more about the consequences of those who have not been convicted and maybe will not be convicted of being held in detention or subject to those conditions?
Indeed. Well, what we're talking about is not only a loss of liberty, but also a loss of dignity, right? And we're talking about populations that have already historically been stripped of dignity. They have no more dignity to be taken away. And this is what happens when people are presumed guilty from the very beginning. They're stamped as guilty from the beginning. It's an affront to dignity. And obviously, it takes away liberty as well, right? So it's doing that damage up front. And we cannot compensate for that later on. This is not about, and I'm sure folks have talked about this before, around, the likelihood of someone pleading guilty if they're denied bail and so on and so forth. I see that my time is up.
Thank you.
Thank you.
Thank you, Mr. Garrison. In the interest of time, our next round will be limited to 3 minutes each, and that'll be our final round. So, Mr. Brock, for 3 minutes.
First question to Professor Jones. I understand you are in the academic field. You're at the University of Windsor, Faculty of Law. Do you ever practice law, sir?
I have, yes.
Yes? Mm-hmm. In what area?
Criminal law.
Criminal defense?
Criminal defense. I worked
Yes.
with legal aid organizations across Canada, Newfoundland, Labrador, Nova Scotia, and
from
Ontario.
what year to what year?
I got called to the bar in 2013.
Okay.
And I practiced up until 2020.
Okay. The reason I ask that is I've taken some notes of some pretty inflammatory language that you're using that, in my view, as a former Crown attorney, is not reality. So I really would like to know where you're getting your data from. Issues such as Crowns in the system are presuming individuals guilty as they enter the bail stage. that Crowns need to be educated with respect to the realities of marginalized individuals, whether they're blacks or indigenous, that the bail system is a proxy for punishment, that judges need to be aware of the racial realities on the ground. Where are you getting this data from?
The Supreme Court of Canada has said it over and over and over again.
Right.
And also
and we
there's
have
been-
Antic, and we have Zora, and we have from the Court of Appeal in Ontario, Morris, which was an anti-black strategy. You're aware of that?
I've written on it.
Yeah, and Crown attorneys from coast to coast to coast receive extensive training, yearly training, if not Crown School, ongoing legal education. So I find it rather offensive that you're just using this broad stroke to categorize the Crown system and the judicial system when it comes to marginalized individuals, black and indigenous, as not receiving a fair shake in our bail system.
This is not my language. The courts have said it, and the courts mentioned it from 1993 in a case called R.V. Parks. This is not my language, that the system is profoundly anti-black. That's
Thank you,
Justice
sir.
Doherty's language.
To Ms. Vlistra. Ms. Vlistra, apart from the small period of time that Professor Jones has actually practiced law, you've been in the trenches day in and day out in bail court over a number of years. You've heard the panel of witnesses today. You've heard references to witnesses who've testified previous. What sort of reaction do you have to what you've heard today? What are the realities? What are the day-to-day realities that you are seeing in the criminal courts?
The day-to-day realities that I see and deal with victims is that most offenders are released quickly and repeatedly. And it's for domestic violence, it's for a wide range of violent offenses, and they're released starting right from when they're arrested by the police and released on undertakings, and they can have a criminal record for it, previous offenses, and then they're held for bail court and oftentimes released on consent by the Crown on their own recognizance or undertaking with conditions of no contact, not attend within 50 meters of a victim, no weapons, and that's where it starts. And then they're charged with usually a breach, or they can be charged with a breach and further offenses, and held and released, slowly climbing that ladder of release. So it's not,
Thank you.
they're charged once, it's repeatedly released.
Thank you, Mr. Brock. To Mr. Zaberi for 3 minutes.
Hello, Mr. Jones, or as they say in Quebec, Maître Jones. I'd like to just open the floor to you so you can give your concluding remarks. And I'd be interested also in your personal experience as a person of color in the legal world. What are some of the, if you want to share any anecdotes, personal anecdotes of how you personally have been treated, or referred to by others, if you found some different interactions from other colleagues of different backgrounds?
I mean, race talk is always uncomfortable, right? And whenever you raise issues of race, there's going to be people that think you are singling out particular individuals or particular institutions. But my data is quite sound. The Supreme Court of Canada backs my data. It's not my data. It's data that has been compiled over the last 30 years. If I had known that I needed to bring that data with me, I would have brought it, and I can send it in at a later date and can be a part of the records.
I would ask you to do that, to send in that data.
That's no problem. But race talk is difficult, right? It's just one of those things. All of us stand to, kind of have that, or kind of sit back and get that talk into, not just Crowns, but defense lawyers and all of the people who work in ensuring that the administration of justice is fair. Right.
Certainly. I'm thinking when I asked the question, I used to work in the Faculty of Medicine at McGill, and one of my academic people I worked with, I was a staff person. One of the academics I worked with, she was a lady of advanced years. She said herself that she was oftentimes thought of as that people would mistaken her for being a nurse or sometimes even the caretaker or janitor of the hospital, whereas she was a physician. And I know that people of different racialized backgrounds in these professions, law, medicine, etc., have different interactions than those who aren't racialized.
That's been my experience. I mean, I've walked into courthouses and, despite the fact that I think I look the part, you're stopped and so on. It's quite endemic, and it's not something that's peculiar to me. It happens to a lot of other racialized lawyers.
So I would say that despite the training that lawyers and prosecutors have, that still, and others in the court justice system, there's still more work that needs to be done. And GLADU is pushing things in the right direction.
Right, and as as the member said, we're seeing the courts, signaling to lawyers in cases like Morris, cases like Lee.
And somebody like you, a PhD candidate who's going to be a doctor pretty soon, I'm sure, for assumptions to be put around your credentials and around your research and your background, your expertise, I find it's really interesting and flabbergasting, to be honest. But it shows that we have a lot of work to do.
You finish your thought and then we'll conclude.
I was just going to say, I have a pretty thick skin. I know that talking about race is difficult and,
absolutely necessary.
Yeah.
Thank you, Mr. Zaberi. I want to thank all the witnesses for attending and giving your very valuable testimony today. Before I conclude, I think the clerk just wanted to mention an event that we've all been invited to. It's, I believe, on Friday. I will not be able to attend, but Mr. Clerk, you want to just read it out real quick to members?
Okay. Thank you, Mr. Chair. I was not aware that I would have to do that now. We will circulate an invitation about an event about Ukraine on Friday night. So it will be circulated tomorrow morning. It's from Parliamentary Center.
I thought we wanted to raise it now.
That's all right. Thank you.
All right. That concludes, and I want to adjourn, and we'll see you all after the break week.